Hey, Brother Wilson, how are you?
Oh, how you doing, Brother Myers?
All right.
Good evening, Brother Bias. How you doing, Brother Wilson?
Hey,
I'm doing well. How you doing, Brother Hines?
Good. I sent Brother Bias the slide deck and the order of the seminar, so you have it as well. But he's immediately going to turn the hosting over to you so you can do the screen sharing.
Okay. And Brother Myers, will you still be able to let people in though, as they?
yeah, I'll let people in.
Okay.
And actually, can you all see when people come in? I'll still let them in though.
Okay.
My video is funky, so I'm just gonna turn it
I,
off.
I see that. I'm like, you
you
must be on a storm over there or something.
No, it's no storm. It's good weather, and it's still messed up. So.
Oh my goodness. Must be that internet connection you got.
Yeah, it's that AOL connection, man. I'm not an
Okay.
early adopter. I got to go with what's established.
So I'm gonna try to screen share it quickly and make sure it works.
Just you can test it. Yeah.
You able to see that?
Yep.
All right, good.
Yeah, it looks good.
Okay. All right, cool.
You can leave it right there, actually.
So do you see like all of my stuff, or do you just see the first slide?
I see all of it to the left.
Yeah,
So are you in
kind of,
slide deck? You in slide? Yeah, you're in slide presentation format too.
yeah,
So
we
is there
see the
something I can
navigation, and
say that again?
we see the navigation slides, and we see the larger individual slide.
So how do is there a way for me to remove that where?
That would have to be done in, I guess it's access.
So-
Is that what you're using?
So at the bottom, you see where it looks like a TV monitor, a slide. Click on that and make sure you're in slide format. Yeah, go all the way down. The next one to the right. Go two over. Keep going right there. Yeah, click on that. And that should get rid of it. Okay.
Okay, so then what do you see now?
Now I see the next slide though. How do you can you click to close that out?
I think, let me do this. Let me, 1 second. Now let me do this. You see that? What you
It's
see
perfect.
now?
That's perfect.
Yeah, that's the full slide
Let
now.
me see.
Yep.
Okay. Okay.
Yep. You got control, brother.
All right, perfect. It's nothing like low control.
I'm trying to give up control in my latter day.
All right, so that's good. So they'll just see the slides. That's what I want.
Yeah.
All right,
So
perfect.
if you can put it on that first slide, just as people come in, that's all they'll see.
Okay. All right, let me do that very quick. Screen share. Is it good?
Yep.
Okay.
Yeah, it's good. And you're the host now, Kevin.
Yep.
So what does that mean? Am I admitting people in because I see somebody's out there waiting?
Hold on.
And should we be recording right now? Because I see the recording on. We need to turn that off.
Okay, I'm gonna reclaim host. Hold on.
Okay. Yeah, we don't want this to go out with the recording.
All right, good evening and welcome, brothers and guests. My name is Hector Cooley, and I am the spring 1979 initiate of the Theta Omega chapter of Kappa Alpha Psi. That's New Mexico State University. I'm the chairman of the Senior Kappa Affairs for College Park-Sandy Spring chapter of Kappa Alpha Psi. I wanted to let you all know that this is being sponsored by the Senior Kappa Affairs Committee. The Senior Kappa Affairs hosts members of Kappa Alpha Psi that are 60 years of age and older. And so this is our committee's presentation of the estate planning seminar. We would like for you to please mute your Zoom call. And we would like for you also to wait with your questions and either put them in the chat or wait until the Q&A. So if you need a pen and paper to jot it down so that you don't forget, please do that. But we want to keep the recording going. We want to keep the presentation going. So that we don't interrupt that. And then at the end, we will make all kinds of time and room for any questions that you all may have. So please keep that in mind. I would, at the beginning of the year, our fraternal year, I asked the Senior Kappa brothers and the committee to, if anyone wanted to sponsor or put out information to the rest of the members. And Brother Hines stepped up right away and said, I want to do estate planning, Brother Cooley, and I want to bring this information forth to the brothers. We then brought in Brother Wilson, of course, Brother Kevin Wilson, who basically does this for a living. And it was meant to have these two brothers together in order to make this presentation. So at this time, I wanted to let you all know also that there's a special announcement at the end of the presentation. So please stand by for the special announcement that we're going to make to you all this evening. So without further ado, please welcome, and I would like to also thank Brother Hines and Brother Wilson for their hard work and efforts and bringing this presentation forward to you, brothers. So without further ado, Brother Hines, Brother Wilson, the floor is yours.
Good evening, brothers. My name is Steve Hines, and I'm a fall 1980 initiate into the fraternity at Eta Omega, which is Old Dominion University down in Norfolk, Virginia. What inspired me to want to do this was as I reflected on my life and the things that I came in contact with through my life. I wanted to make sure that I shared my knowledge with brothers because we as Black people don't do these things typically. And I just wanted to make sure that you all were aware, and Brother Wilson is an excellent resource for this. So I'm happy that, he's able to share his knowledge as well. But before we get started, I just wanted to kind of reflect on 3 short stories that inspired me to actually go in this direction and make sure I had things in order for myself and my family. The first one was related to one of my uncles who was in the hospital. He had 3 sons and he had a rare heart condition. And he was basically on his deathbed and the doctors wanted to do another procedure. They were asking about medical directives and things like that, and nothing was in place. So his 3 sons were there by the bedside, so as I. And when I watched them have to lift his hand to sign that paper to get the procedure, I said, that's something I never want to ever put my family through or go through that situation myself. That was the first story. The second was my mother-in-law had major surgery back in 2010 and had to go into a rehab facility. While she was there, I came in contact with a young lady who was a speech pathologist, and she was basically a paraplegic. She couldn't even talk. She had to use a keyboard to speak, and she was probably in her 20s. That also raised some flags for me as I thought about my daughter and other members of my family to say, this has no discretion to age as far as what can happen to you. So you need to have things in order no matter what age you are. So we put things in place for my daughter as well. And then the last story that I want to mention is, as you all know, I'm a caretaker for my in-laws who live with us. When my mother-in-law had her surgery, and then they moved up here from Virginia Beach area to live with us, we were asking about, any type of trust accounts they had to protect their assets and everything that they've done over their 90 years of life to save. I don't want all that to be dissipated on medical care and things like that. And then I found out they didn't have long-term care insurance. And I remember when my mother-in-law had surgery, she had to have 24-hour care. That was $12,000 a month. So I quickly saw how that could drain your assets when you don't have the proper things in place. So those are the things that inspired me to go in this direction for myself. My wife and I have created trust accounts. We have our assets in the trust accounts. And Brother Wilson will tell you more about the look back process that Maryland has and Virginia as far as what that process means. But that was my inspiration to make sure me and my family was in order, and that I have one daughter. I didn't want her to have to go through any struggles dealing with death or any type of sickness, being that she's the only child. So I just wanted to share that with you, and hopefully that inspires you all to take some action for yourself so that you're protected down the road. So with that said, I would like to move into the agenda for the evening. The things that we're going to talk about this evening is, what is estate planning? Why is it important? What happens when you don't have an estate plan? And then the major components of an estate plan: a revocable trust, the last will and testament, durable general power of attorney, durable medical power of attorney, and your medical advance directives and living will. So with that said, I'd like to turn it over to Brother Wilson, who will take us through this journey of understanding what we need to do.
Thank you, Brother Hines. Good evening, brothers. Kevin Wilson, Esquire, College Park-Sandy Spring, Spring 22. I must first start by recognizing that my MTA chair and assistant MTA chair are present. I'm excited about that. I start with that because during the process, which was just last year, I was tasked with putting together a proposal of what I would bring to the chapter if I was so fortunate to become a member of this chapter. And the proposal that I put together was that I wanted to do this very thing here, which is provide members of the chapter as well as people beyond the chapter with information pertaining to estate planning. So it's exciting for me to be able to do this with my MTA chair and assistant MTA chair present, just confirming for them that I truly am that man they thought I was, which is a man of integrity and a man of my word. With that now out of the way, let me say to you that it is my pleasure, and I am super excited to be speaking with you this evening about estate planning. And there's a number of reasons for that. One, estate planning is just so important that it is not a choice as to whether we put together a plan. It is our obligation to ourselves and to the ones we love the most. Secondly, like all good, valuable information that is shared in this country, the full understanding and advantages associated with estate planning is information that is slow and late to get to our community. And third and lastly, some 15 plus years ago, I actually challenged myself to make sure I provide everybody in my community with information and knowledge about estate planning. And by you being here this evening, you are helping me with my efforts. Before we dive in, please allow me to share with you a little bit about myself. I've been practicing law for over 22 years. I'm licensed in Maryland, DC, and Virginia. 80% of my practice is devoted to estate planning. 10% to federal defense, and the other 10% is to personal injury. I live in DC and my office is located in Chevy Chase, Maryland. I'm now just going to share with you just a short story as to, like Brother Hines did, what piqued my interest for estate planning. My interest in estate planning began 15 years ago when my mother was in her final stage of life. My mother had done some planning. She's one of those that I say was a person that was before their time as far as her thinking. I, along with assistance from a colleague, was able to supplement my mother's plan before she died. When my mother finally passed on, the planning, I must tell you, the planning made life during that time of my mourning and my brother's, it just made things much more manageable, emotionally, mentally, and physically. And that was for one reason. And that's because I knew what my mother's wishes were. And it was after that experience that I then made that challenge to myself that I spoke about earlier. It was such a great experience for me that the conversation I had with myself is I have to make sure everyone knows about planning for the inevitable, which is our passing. So here I am. Let me see. I am sure, like me, many of you have heard about wills, but you've never had a full understanding of wills. And like me, you probably heard the word trust, but you thought it didn't apply to you. Most of us, when we first hear trust, we think you have to be rich to have a trust. Well, I'm here today to set the record straight and to provide you with the needed information to assist you in caring for yourself and the ones you love the most. So what I'm going to be providing you with is like a 30,000-foot view of estate plan. So in accordance with the agenda, let's get started. First, we're starting with, so what is estate planning? Estate planning, it is the process of planning to control our property and assets while we are alive. It's also to take care of us, our loved ones, if we become disabled, and after we pass on. It's also planning to give what we have to whom we want, the way we want, and when we want to. An estate plan aims to preserve the maximum amount of wealth possible for the intended beneficiaries and provide flexibility for the individual prior to death. And just so you know, I'm going to get more into these, but I'm just giving you just a quick summary of what estate planning is, which I would do for all the topics that comes after this. And finally, estate planning assists us in avoiding probate. Why is estate planning important? Well, ultimately, it allows you to preserve what it is you have worked so hard for all these years and pass those things on to those you want to have them. So, for example, I often refer to, way back in the day with our grandparents or great-grandparents, if they couldn't afford anything, the one thing they made sure they took care of, that was making sure they paid for the roof that was over our heads. They're gonna pay that mortgage regardless. We may not eat that night, or may go without some clothes or wear clothes with holes in it, but they're gonna pay the mortgage because they are going to protect and preserve that home. But what ultimately happened was when they died, because they didn't have a plan, that house that they put their everything into was auctioned off on some courthouse stairs to someone outside our community for little or nothing. So that home was gone. It didn't stay in the family. It didn't pass down to the next generation. It was somewhere else other than with us, and it was just gone, never to come back. So we have to change that narrative. Estate planning is important because it allows you to create your own legacy. With estate planning, most people think that it's passing down money and money alone. No, it's a lot more than that. You can pass down money, you can pass down property, you can pass down values, you can pass down traditions, you can pass down all those things that have made you the incredible people you are, and the model that you try to set for your children or any and all those that are looking on. Those things can be passed down too. And what happens is you create your legacy. Estate planning allows us to eliminate stress and uncertainty and family mess. So I take you back to the story about my mother. Because she had a plan with instructions as to how she wanted things done, I had less stress. There was no uncertainty. It was in writing exactly what she wanted. All I had to do was simply follow her instructions. And family mess, I have that in bold, because us as estate planners will often tell you that if you want to see people change, show them a dead or sick body with money. And trust me, people change, and not for the better. Estate planning also protects beneficiaries. You heard Brother Hines speak of trust. You know, a trust is in place, not so much to protect you as the trust maker, but definitely it protects your beneficiaries. And there are reasons for that. And without getting too deep in the weeds with it, I would just simply tell you that the trust, that there are two types of trust. There's revocable and irrevocable trusts. I recommend to most of my clients that they get revocable trusts. Why? Because they still have plenty of life to live. So that means they're going to be life changes. They're going to accumulate more stuff. They're going to lose some stuff. They're going to trade out some stuff. And by having a revocable trust, they have control over the assets that are in the trust. And they also have the ability to make amendments and changes so long as they're alive. So with that, having a revocable trust and all that control over it, it doesn't provide you as a trust maker with protections. But once you die, it then converts to an irrevocable trust for the benefit of your beneficiaries. And because it's irrevocable, it protects the assets that are within and wards off people trying to get at those assets because they simply can't. So for your beneficiaries, there's plenty of protection that's in place. Also, if beneficiaries are young children, with trust, as you want them to have access to what you've left them, take, for example, if at 25, my mother left me $1 million, probably by the time I was 27 and a half, I'm sure I wouldn't have most of that money. That's because, unlike probably most of y'all, I wasn't that responsible at that age. So what we do when we have young children is we have that trust, and we may make contingency distributions. For example, we could say that once they graduate from college and or turn 25, then perhaps they can have access to 25% or withdrawal rights of 25% of what's in the trust. And then when they turn 30, they can get another 25%, all the way up to the age of 40, then they have access to withdraw up to 100% of it. It's just to control their spending habits, just to make sure that they're not sort of hitting the lottery and then trying to figure out what to do with all this money. It's to help them manage the money and the assets that are within the trust. And finally, it also spares your heirs with, as stated here, a big tax bite. One of them is estates can be taxable. But there's a sort of forgiveness amount that exists where it will not be taxed. And right now that's up to over $12 million. So by having it in a trust for your beneficiaries, when you pass, unless your estate is over 12.5 million, there's not going to be an estate tax federally. And there are some states that have state taxes, and Maryland's one of them, but Virginia and DC, they do not. No, DC does as well, but Virginia does not. And it's a little less than the 12.5 million, but still yet you're saving if you have your assets in a trust and your heirs aren't having to satisfy that tax bill. Of course, they can use the assets that are within a trust to pay that tax bill, but why give up that money if you don't have to? All right. So let's move on to the next slide. What happens when you don't have an estate plan? Well, the state has a plan for you. They always do. Usually the unfortunate part about that is the plan that the state has for you isn't consistent with the plan you would have for yourself if you were the author of your plan. And what I mean by that is, if you don't have a will, if you don't have a trust, when you die, the state takes control of your estate. They determine the value of your estate. They determine who gets what from your estate. They determine when they get things from your estate. You know, we're all probably old enough to understand that, you know, there's relatives and then there's family. And they're not always the same, if you know what I mean. Those people you call family, they're relatives, but there's some relatives that you don't call family. Well, if you don't have your own plan, it may be some of those relatives that the state decide they're family, and they're then entitled to your assets. So I just believe, and I think all of y'all would agree with me, it's better for you to be the author, if you will, of your life plan than to have the state be the author of that plan. Let me see if there's anything else I want to add to that. So there are other things. So when you die without a will or you die without a trust, like I said, the court steps in, your assets are tied up in probate court. So like I already stated, the court defines who your family is, the court determines who gets what from your estate. But in addition to that, your information becomes public, meaning any and everybody out here in the public can find out what it is you left and where those things, where they end up, in whose hands. And you know, one danger with that is, believe it or not, there are a lot of scammers that they track obituary pages. They are in the courthouse looking to see who recently died and what they left. And what they do is they get on the phone and they start calling people. And they come up with every scam you can imagine to try to cipher money and assets from the people that just inherited those things. So by your information becoming public, it's, I'll put it this way, it's not a good look. And it only invites, you know, the uninvited. So we want to avoid that. Also, you may incur unnecessary expenses, right? So the court has determined the value of your estate. Sometimes that requires the court hiring an accountant. Your assets are held up in probate, so it allows creditors who believe they have a claim against you to file claims. Also, it allows those relatives to come in and contest whatever it is, the decisions the courts are making. So with those being the case, the court may have to hire not only an accountant, but also perhaps a lawyer to defend your estate. And your assets end up getting tied up for months to even years. And this is definitely an important note for those that are married. And the example I would give you is you're married and you and your spouse depend on each other to take care of your monthly expenses. So when you die and all your things are tied up in probate, what is your surviving spouse to do? They're used to you giving half or 75% or more likely to 95%. But they can't get access to that because it's held up in probate. We want to avoid that because what does that invite? That invites foreclosures, that invite bad credit. That just invites, once again, the uninvited. So let's avoid that. With the trust, that's not a problem. There is no court. And I'll get into this more a little later. Let's see what else. So those are the main reasons why we want to put together a plan and avoid dying without a plan. Because as my theme has been thus far, it just invites the uninvited. So let's talk about the components of an estate plan. And I will just tell you from the door that the components you're going to see are what I call like the pillars of an estate plan. It's not everything to it, but these are the major components, the driving forces of an estate plan. So let's start with the revocable living trust. As I stated earlier, there's a revocable living trust and then there's irrevocable trust. Most of my clients are going to have revocable living trust. Some of them are going to have both. You know, there may be a family home that, you know, we've decided it's been passed down to you. We want to pass down to every generation to come. We never want to sell it. That's something we can put into an irrevocable trust, right? Because we're not planning to ever have any one person own it. We're planning for it to just survive generation after generation. And one of the reasons why we would put it in an irrevocable trust is because the value of that home doesn't go towards that 12.5 million that I was telling you about. By being in a revocable trust, it's not included in the value of your estate. So that's one of the reasons why we would make a decision such as that. And then there are others. But the revocable living trust, unlike a will, unlike dying without a will, with the revocable living trust, your assets are transferred to your loved ones immediately. In that husband and wife situation, that wife or that husband is not waiting for things to get hashed out in probate. That husband and wife is not in jeopardy of foreclosing on the home. That husband and wife is not damaging their credit because they don't have that resource that they were accustomed to. With the revocable living trust, your assets get transferred immediately because you would have left instructions as to how you want your assets distributed. You would have chosen a lineup of trustees to carry out your wishes and your instructions. So that's the major beauty of a revocable living trust. It transfers your assets immediately. By avoiding probate, we eliminate those unnecessary expenses. We cut out the time that your assets are held up in hands other than your loved ones that you want your assets to be in their hands. Also, with the revocable trust, I just lost my thought, but I'm going to get it back. Everything remains private. The only people that are going to know about your assets and who they're going to are going to be your trustees and your beneficiaries. That's it. No one else. It remains private. It remains sacred. It remains in the view of those that you want to be able to view it. And that's it. No one else. Last will and testament. In my plans, I refer to it as a pour over will. So this goes hand in hand with the trust. So imagine a trust as a big bucket, And the goal is to get all of your assets into that bucket. But as it probably will be, life is changing every day for you. You're accumulating things every day. You're trading in things every day. So there may come and you don't know the timing of your death. No one does, right? So there may come a point where you die and something's left out of the trust. Well, that's where this will that I refer to as a portable will comes into play. So what happens is, if it's outside the trust, where is it going? It's going to probate. It's going probate via your will. Well, we would have already planned for that, meaning you would have already determined who you want your personal representative to be. And you will have already left instructions as to how you want your will administered as it relates to assets that fall up under your will. So the reason why I refer to the will as a portable will, because in my plans, the will simply says, take this asset, transfer it over to the trustee of my trust, have that trustee pour it into my trust and administer it the same as the other assets that are already in my trust. So the point of it is, one way or another, we're going to get everything into your trust. The only things that will be outside your trust would be, like I said, those things that inadvertently didn't make it into the trust. And then I recommend not putting like automobiles in a trust. Things that invite, once again, the uninvited, be it litigation for one reason or another. For example, you get into a car accident. If they don't know that you have a trust, they're not looking for a trust. But if they know that you have a trust, now they're looking for a trust and all the things that are in a trust. So in case you didn't know, typically with like personal injury, automobile accidents, you have an insurance policy, get into an accident. If it's your fault, the attorney usually will just go for at most the maximum limit of your insurance policy. They usually do not sue beyond that. Best believe if they know that you have a trust, they're going to sue for the insurance max, as well as any and all assets that they discover that's in your trust. So for that reason, we don't want to put like an automobile or some recreational vehicle that you have in your trust. We have other ways to account for that. For example, in DC and Maryland, if you have a car, there are forms where you can fill out and place beneficiaries for transfer on death. So that's how we avoid probate with those items. Even if they don't make it into the trust, you fill out the DMV form, you designate who you want the beneficiary to be, and the form simply says that when I die, transfer ownership of this asset to X. We avoid probate, and we're still able to leave it outside the trust so we don't invite the uninvited, which is some litigious person that knows you have a trust and want to go after everything that you have. So that's what we do with the will, and that's how the will comes into play with a trust. Next, we have power of attorneys. I'm going to go over two of them. The first one is this durable power of attorney, and then I'm going to go over healthcare power of attorney. The difference between the two is the durable power of attorney handles your financial matters, your day-to-day activities. You're going to designate someone to be your durable power of attorney. In the event you become incapacitated, disabled, incompetent, you'll have someone designated to carry out these functions for you. Recently, when I've been giving these presentations to potential clients, I've been talking about the Buffalo Bills player. Most of us know about that, right? So best believe before that game, he never envisioned that he would die on the field and be revived and then laid up in the hospital, just completely out of it, unable to make any decisions for himself for a handful of days. Well, if he had a plan, then he had a power of attorney, he had trustees. These people were in place to carry out his wishes and his business, and even make medical decisions for him. If he didn't have these things, then he ran the risk of the court having to intervene and appointing a conservator or personal representative to do these things. And once again, the people that the court may appoint aren't necessarily the people that, if he had his choice, he would have chosen. So let's be the author of our own plan and not let the state be the author of the plan. The next one is the healthcare power of attorney. This gives someone the authority to make medical decisions for you when you can't make them for yourself. Once again, the Buffalo Bills clear. Someone had to give the surgeons, the doctors, the go ahead to do certain procedures. And by having a healthcare power of attorney, you designated that person that you trust the most to make those decisions for you. And they're in place to make those decisions. So if you haven't caught on, the theme of this is of this whole estate planning thing is for us to plan for those unexpected events that inevitably they happen. They happen all the time. Like I said, before the guy went to the field, he never envisioned that he would be dead on the field, revived and carted off. But life happens and it's hard to predict, if it's even possible to predict it at all. So the key thing with these power of attorneys is, as the bottom statement says, make sure you're choosing someone that you definitely trust, that they know you well enough that they will truly carry out your wishes. These are people that have been around you. They know what you're about. You've had conversations with them, whether it was directly or just shooting a breeze, and they have a good understanding of who you are and how you conduct your life. So that's important. Next, we have a medical advance directive. It's referred to as, by a number of names. Some people refer to it as a living will, some people as a medical directive. But what it is it provides instructions as to how you want to be cared for in the event you are either diagnosed with a terminal illness, whether you're in a vegetative state. It gives instructions as to how you want to be cared for. For example, do you want to be placed on artificial life-supporting devices? Do you want to use experimental drugs? Do you want to be resuscitated? These are instructions that you can leave behind. And oftentimes, if I ask, do you want to be resuscitated? Most of you, if not all of you, are going to say, well, yeah, of course. Do you want to use experimental drugs? Well, if the alternative is I'm going to die, then yes, I do. Do you want to be on artificial life-sustaining machinery? Well, that's a mixed bag as to whether you do. But what comes with those decisions is you get to also include, and I often suggest that we include, if you say you want these things, is that if it's determined that you are in a permanent vegetative state, you have a terminal illness, an incurable condition, and therefore you will be unable to experience a meaningful life, that even if you select to be resuscitated, and even if you select the experimental treatment, under those conditions, you may want to revoke your consent to those things. So we try to anticipate the various scenarios and make sure we provide an answer for the various scenarios. But ultimately, the decisions are yours. I just suggest some things for you. So there it is. This reminds me of some other things. You get to choose whether you want to be an organ donor. Clients of mine that choose to be organ donors, I also add a clause that states that, these organs are to be donated to family members first. They sort of get first right of refusal. Then if they are not in need of the organs, then the organs can be offered to the general public. You get to determine whether you want to be cremated or buried. Cremation is becoming the fastest growing popular way that people want their remains disposed of. It used to be being buried, that's fading. Now people want to be cremated. So you get to make those decisions. And by you leaving those instructions and making those decisions, you make it much easier on your loved ones. Once again, referring back to my mother, quick story. My mother grew up in a small town. They had the family graveyard, right? And the church that she went to as a kid. But my mother left this town by the time she was 18. But the question for me was, does she want to be buried with all her family members? And that's what I was going to do until I went through her plan and realized she had already bought her plot and her vault. And it became clear to me where she wanted to be buried. So once again, you know, the answers were there. I have no regrets or woulda, shoulda, coulda, or none of that. The answers are there. And that's the position I believe you want to leave your loved ones. Here are just some things that, as I put up here, something to chew on. Do you know that more than 70% of Black Americans don't have a will? And the most common reason given for that is they plan to, but they just haven't gotten around to it yet. Like I said at the beginning, it's no longer a choice. It's your responsibility. And if you don't do it, at best, you're negligent. Did you know that estate planning is the largest wealth transfer in history? If you were wondering during your younger days why, you know, the kid to your right or to your left, they seem to have a lot more than you, and life was a little easier for them than for you. In most circumstances, for most of us, it was because, like I'll use myself, for me, I was starting at ground zero, if you will. You know, I wasn't propelled because someone left me something behind, you know, to give me a boost. You know, I used to hear the stories, back in my day, we walked 2 miles to school in 2 feet of snow. Even as a young kid, my thought was that I should never have to do that. Because if you've done it, you know how to navigate around that. And that's what estate planning is about. You know, transfer that knowledge, transfer the assets, you know, transfer, you know, traditions, transfer your visions on life, things that you learned. We often tell people that if I knew back then what I know now, you know, I would have made a lot of different decisions. Well, leave that behind for the generation behind you so they don't have to have that same conversation. And then finally, I'm going to leave you with this quote from this attorney. This attorney was describing how she had been involved in estate planning for over 25 years and just being involved and doing administration of estate planning. She saw so much money that was lost because people didn't have a plan. And what she got from that was this statement here. If the African-American community got on the good foot and every Black person who is alive over 60, talking about just people over 60, did their estate planning, we'll be the richest minority group in the United States within 1 generation. Now, in this quote, it talks about the age of 60, but please understand, we're never too young to start estate planning. If you have a home and nothing else, you need to do estate planning. If you have your jewelry and you like to bling out, and you have clothing, you have furniture, you need to do estate planning. You know, we'll tailor your estate plan to your assets, to your needs, and to your loved ones. So there's no age where you're too young to start doing estate planning. Here's what I label as a fact for you. It is important to take a step towards creating an estate plan because you can't afford not to. The economic cost is just too great to do nothing. It's time for us to catch up. If not us, then at least the generation behind us. So here's what you can do next. Because it's not a choice, you need to sign up for a 30-minute free consultation with me so we can talk about your specific situation and come up with some strategies of how estate planning can assist you. No commitment other than your time. And the way you can do that is just by contacting me with the information that's on the screen. Or you can put your information in the chat. So I only hope that this presentation was informative to some degree for you. I hope it has lit at least a little fire under you, that if you haven't gotten your affairs in order, that you start with a plan like this moment, even if it's just thinking about what your next steps are going to be. Estate planning is important. And my sign off is always get it done, even if it's not with me. Get it done. Thank you very much. I appreciate your attention. And I'm so glad you all are here. Thank you.
Thanks, Brother Cooley, for that great message and valuable information. What we'll do now is I've asked people if they want to put questions in the chat, they can do it that way. And once we go through that, we can open the floor up for questions if you want to ask your questions out loud. So the first one that I have here in the chat is from Brother Jerome Parker. What about the Ladybird deed? Is that something that you can address?
I've never heard of a Ladybird deed.
Brother Parker, do you want to give further explanation on your question?
It might just be something that's localized to Michigan. When my father passed away, our property was passed to us by, I guess, what they call a Ladybird deed, in which he pretty much had us named inside with his will, a document that pretty much transferred the title of the property directly to me and my brother or whatnot. I was just wondering, you know, when you're bringing something else, I wasn't sure if you might discuss that when property like a house or something like that is transferred. And again, they use the term Ladybird deed inside Michigan. It might just be might be another term for it in Maryland or something else.
That's fine. However, it's labeled, it's all about how it's executed. And what it is simply is just naming you and your brother as the beneficiaries of the house. So if you have a trust, you can make a specific distribution for something like the house. So what I mean by that is, you know, within your trust, you're going to have a lot of assets other than the house, right? And you may say that you want your assets divided up in percentages to all your kids, if you have, say, 5, but you want the house to just go to 2 specific kids. Well, we can do a specific distribution of the house within a trust and then still have the remainder of the assets distributed to whomever, however. So yes, it's just making you a beneficiary of the house.
Yeah, Brother Wilson, I see Brother Griffith has put a comment in regarding the Ladybird deed. It's also known as the enhanced life estate deed. It's a way to transfer property to someone else outside of the probate while retaining a life estate in the property. In Maryland, there are 2 options for this type of life estate deed with powers.
So once again, how we label it, I mean, we can call it whatever, but so Brother Griffin is mentioning something a little different than what Brother Parker mentioned. Brother Parker was talking about the house going to the 2 brothers. Sounds like what Brother Griffith is talking about is where, remember the house that I said that we might want to put in an irrevocable trust? In that instance, we're designating beneficiaries, but they are just beneficiaries so long as they live, therefore giving them a life estate in the house. Is that distinction clear?
No, it's not clear.
With Brother Parker, they're named beneficiaries. So when they get the house, they can take the house and do whatever they want to do with it. They can sell it, they can live in it, they can do whatever. With the life estate, you have access to the property, meaning you can live in it, but you can't sell it. And you only live in it so long as you're alive. Once you die, then there's probably another beneficiary that it would then go to.
Okay.
Okay, I get it now.
Okay. The next question is, I think it's from Brother Gladden. It's about the 5-year look back period. Please explain that in regards to nursing home care.
Right. So what people do is they participate in a presentation like this. They find out about a trust. They marry that with the information they have about, like nursing homes, right? Meaning if you go into a nursing home and you have assets, before you can go in that nursing home and stay free or have the government pay for it, you have to exhaust your assets, right? So then what some people think is, then perhaps I'll put those assets in an irrevocable trust where I don't have control over it. It's not a part of my estate. And then I can hold on to those assets and then get into the nursing home. Well, what the nursing home, what the law says is you can do that. But what happens is they're going to look back 5 years. And if you made that irrevocable trust within those 5 years, then those properties are counted against you. So that you have to put them in there, survive it 5 years before you need a nursing home. Otherwise, those properties are going to be counted against you as it relates to getting into a nursing home and having the government or subsidies pay for your stay there.
And Brother Wilson, that's one thing that I did for my in-laws. Their trust has been in place over a 5-year period. So I know the government cannot see those assets, their savings accounts and things like that at this point to deny them access to support. Got another question about what about long-term care insurance? When should you get it?
No, I really don't participate a lot in the education of long-term care insurance. I am associated with a person that sells insurance and does all the presentations and provide information about long-term care insurance. So that's not in my ballpark.
Yeah, and I can speak to that as well. That's something that my wife and I put in place when my mother-in-law had her surgery and they didn't have long-term care insurance and we were paying $12,000 a month for 24-hour care in the household. So we took out policy on ourselves as well as our daughter, just in case something happens. And what that helps to cover is cost of in-home care as well as nursing home care or rehab care if that comes about. The other question is, without a will, what about the widow's share or the widow's mite?
So I am assuming that they're talking about elective share.
I believe that's from Brother Gladden. Is that correct?
From John Bias.
Oh, Brother Bias. Okay.
Are you referring to elective share?
Well, no, I'm using the case of my mother and her uncle and his second wife. My uncle raised my mother, my great uncle, I should say. My great uncle raised my mother almost as a co-parent for her entire childhood. He initially had left his estate to my mother. Then he got married a second time, and the second wife went to court and asserted her widow's mite portion, meaning the state of Maryland dictates how much a widow gets. Even if you leave everything to somebody else, the widow doesn't get excluded. And my uncle was the type who, once he set his will, he wasn't going to change it for anyone, even a second wife or a third wife. So the court basically, I forgot what the disposition was, but she got a hefty share of the estate and my mother got the other share.
Absolutely. So once again, it's a play on the terminology that you use. That's elective share. And that's in place where states do not allow you to disinherit your spouse. Meaning, you know, if you and your spouse not getting along or things aren't on track, then you better get a divorce. Because if that person is your spouse, you can try to leave them out of your will, you can try to leave them out of your trust, or you can try to leave them bare minimum. But there's an elective share that they are entitled to. In some states, it's half. Some states, it's a third. But in some states, it's everything. So they are entitled to their elective share. And if you pass and you leave, and they think their elective share would be more than what you left them, then they will go to court, and a judge will give them their elective share. Or if you leave everything to mama and nothing to them, they will go to court, and a judge will give them their elective share. So yes, that's what that is. And that exists on the law books in all states, at least the states that I practice in.
Thank you.
Sure.
Okay, the next question is, and I believe it's, what about the descendants' debts? Who is responsible for those debts, the spouse or the estate?
Decedent,
Oh,
the dead person.
what is a decedent?
All right.
Yeah,
So
the decedent share.
Okay,
right. So if you have a trust, when someone dies, that trust is referred to as what we call an administrative trust. And what that means is there's that period right after someone dies where whatever's within their trust, their assets, will take care of their debts, taxes, or whatever you have. That is done first. And then whatever's left after that then filters down to the beneficiaries.
okay, thank you, Brother Wilson. Next question. I am in my early 20s and I have a 2-year-old kid. I have constant fights with my child's mother. I live at home with my mother and have no car or other significant assets, but I do have a job that gives me $100,000 life insurance policy. Why would I need a will?
Well, I would say not only do you need a will, you need a will and a trust. I'm assuming, and you can correct me if I'm wrong, based on what I heard, you have a life insurance policy. I'm assuming you have that life insurance policy for your child. And if something happens to you next year, I mean, I think you said a young child next year, would you want an insurance company to stroke a check in the name of that child for that full amount, where whoever the guardian or personal representative for that child have access to all that money that you probably really want to be in place for that child to go to college or buy the first home or his first wedding or something like that? So the point is, with the trust, what you could do is you can have the trust as the beneficiary of the life insurance policy. So what that means is if something happens to you, the insurance company writes a check to the trust. And then within that trust, you have your child as the beneficiary. And like I talked about earlier, we've put in your trust that your child starts to get access to whatever you leave your child when first they either graduate from college or turn the age of 25, right? And then they can get access to, say, 25% of that $1 million. And then when they turn 30, they can get access to 50% of it, and so on and so forth in those 5-year increments or whatever increments you decide. But let me make sure I'm clear that even when I say your child can only get access, I'm talking about withdrawal rights. As long as that money is in a trust with your child named as a beneficiary, your child will always be able to benefit from that money. And we have a standard that we put in place. We refer to it as an ascertainable standard, which that trust will be for the health, education, maintenance, and support of your child. And your trustee will be able to provide for your child. For example, if your child is not 25, hasn't graduated from college, but there's some huge medical bill, the trustee can stroke a check to assist with that. If your child is engaged in extracurricular activities and whoever the guardian is need assistance or help with that, then your trustee can write a check for that. So even though you're single, even though you're young, the fact that you have a child and you have this insurance policy, it would behoove you to look into getting an estate plan. So not only would I recommend a trust, but like I said earlier, with that trust will be a will as well.
But Brother Hines, that was a setup for Brother Wilson.
Brother Wilson, you
Set
can
up.
stop. You can stop your screen share. We can see your face instead of having to just look at the. There you go.
Okay.
Okay, the next question, well, not a question, but Brother Griffith put out a URL to access a blog as it relates to a Ladybird deed for everybody's reference. Next question comes from Brother Paul Bias. What's the cost to maintain a trust and what's the cost to set it up?
Depends. The most popular words for an attorney, it depends. I can give you a range. My plans range from, as it relates to trust, anywhere from $5,000 to $7,500. And then I have wills that range from $2,500 to $5,000. And it's just hard to give a number without knowing exactly what we're doing and everything we're doing. And let me just give you this example too. So like right now, I'm in the process of putting together a trust plan, and I printed out the documents. This trust plan is going to be close to 200 pages of documents. So we're not just talking about a 1 or 2 page power of attorney or 1 or 2 page will, trust, all those things. No, these are very detailed, in-depth documents. Like I said, we're trying to anticipate all the various scenarios. Of course, we will never be able to capture every single scenario, but we're making an effort to do that. So those are ranges that I can provide you.
And to speak to Brother Wilson's comments there, my package is in my safe, and I will tell you it's at least 4 or 5 inches thick. So there's a lot of paperwork associated with it. But what I did for my daughter, I said, if you don't have access to my safe, there's one phone number to call to the lawyer and they will take care of everything. So it just makes it easier on your family. We got another question in here.
Let me do this real quick before we go to the next question.
Mm-hmm.
I want to do this in front of everybody. I owe Brother Henry an apology because he reached out to me via Slack a while ago pertaining to estate planning. I wasn't on Slack. Brother Bias can let you know I was just able to get back on Slack maybe a couple of weeks ago. So Brother Henry, I apologize. And if you still need to talk to me, I'll reach out to you and we'll figure that out. But I wanted to extend that apology. I wasn't ignoring you. I wasn't on Slack.
So we have another question here. Can you disinherit your kids?
Yes. Yes, you can.
Okay.
Yeah, but let me just, that was my question. In a scenario with the spouse, they're able to go and sue and get their rights. Can kids do that?
No, you can disinherit your kids.
But in your explanation, the second wife or wife, she's written out the will or whatever, and she had the ability to go and get her designated compensation or inheritance from each state in the union. Can kids do that also? or there's no guaranteed benefit for kids?
Law specifically has a provision for spouses. I'm telling you today, no for the kids, but what I'm going to do is check to make sure what I'm telling you is absolutely correct. And I'm going to get back to you and confirm that for you. Is that satisfactory, Brother Gladden?
No, great. Yeah, that's great.
Okay, good. Next question is from Brother Frank Griffith. Are there any special provisions that should be considered in trusts and wills in dealing with non-US assets?
It is. Not only for non-US assets, but also even for non-US beneficiaries, non-US citizen spouses. Yes, there are provisions that specifically have to be placed within your plan to cover those.
Okay, hopefully that answered that question. I think the last question in the chat I have is, in your experience, is the planning process a one-time event, or is it something that should be updated periodically? If yes, how often?
So what I would tell you is a part of the conversation I have with my clients is I tell them that as a part of your consideration as to whether you want to engage in this business relationship with me, one thing you have to consider is that I'm going to be in your life for years to come because the laws change. Life for you as an individual constantly changes. Therefore, there's going to be times where we're going to need to make changes to your plans. We're going to need to make edits to your plans because your life has changed, because the law has changed, and so on and so forth. And even like with what I gathered from the question that can we let Brother Henry in? Like even what I gathered from the question that Brother Henry had left me, like when your children, I'm going to know when your kids turn 18 and they're off to college, there are packages that we put together for them, even if it's nothing other than, you know, some power of attorneys or filling out a HIPAA form. Because what happens, you have a child, they're in college, say they're on the West Coast, you here on the East Coast, they're in the hospital, you call up and you say, can you tell me what's going on with my child? And the doctor's like, well, you know, I'm sorry, I don't have permission to share that information with you. And then, you know, we get indignant. What do you mean? I'm paying for his tuition. That's my child. You better tell me. And the doctor's like, I'm sorry, I can't provide you with that information. So we put together packages for kids for situations such as that. If they are sick under the weather and you need to get to their bank accounts or all these things. So I'm going to be in your life for a while, and we're going to constantly do maintenance. You'll always be able to call me when there's a significant change in your situation. And if I don't hear from you, I'll follow up with you every 2 years and then 3 years after that. You know, there are incremental periods in which I will follow up with you. So it's not a one-time thing.
Right.
It's the short answer.
One thing I did want to mention, and this is dealing with another event, I mentioned in our last chapter meeting, my daughter was getting married. Another reason why I created a trust was to protect her, being the only child. I don't know who she's going to marry. You know, I never knew all of that. Thankfully, she's marrying a fine young man, but you never know. So I just wanted to make sure that the assets that my wife and I have built over the years were protected, and she had total control over those assets. So that's another reason why we created the trust.
Right. So long as the assets that you leave to your daughter are within the trust, if her marriage doesn't work out, the husband doesn't get half. He can't touch those assets that are in the trust. If you have a child that you know is not responsible, you get to control how much of the assets from the trust they get. Example, not to say this guy isn't responsible, but thank God the Philadelphia 76ers put money in a trust for Allen Iverson. Had they not, I don't know. But I know right now, even where he may have fallen off a little bit, he's back because I think that the period for him to start withdrawing from that trust has come about. So, you know, good forward thinking for the 76ers as it related to Allen Iverson. But these are all the good reasons why you want to consider a trust. You get to control it and help those that need help, even if they're your beneficiaries.
And Brother Wilson, can you explain when you say put things in the trust, how that relates to funding the trust?
Okay, so like I said, imagine a trust as a big bucket, and the goal is to put your assets in a trust. The way you do that, there are a couple of ways, but the main way is you just have to change the title of the asset. For example, say my home is in the name of Kevin Wilson. If I want to put it in my trust, and when I put it in my trust, then the title on the deed is Kevin Wilson as trustee of the Kevin Wilson Living Revocable Trust, and any amendments there too. So there's a legal way in which to change the title of the asset so that it is lawfully in your trust. Now, when we talk about tangible personal property, things that you can touch, pick up, move, and all that thing, there's a document that's a part of my plan that I have you sign. And when you sign that document, you officially transfer all of those tangible personal properties into your trust. And then what I give you is a memorandum. It's a personal property memorandum. And what you get to do at your leisure is to describe those tangible personal properties and even designate who you want that particular item or asset to go to. All that incorporated becomes a part of your trust and is left for, you know, your trustee when you pass on. So that's how we do that. We just change the title. Savings accounts, take it out of your name and put it in your name as trustee of your trust. Then it's lawfully in your trust. You know, life insurance policies, you can do the same thing, although we don't recommend that you change that. You want to leave the life insurance policy in your name. However, you can make the trust the beneficiary. But that's how you would do that. And people do refer to that as funding your trust.
Thanks, Brother Wilson. Another question is the executor of an estate, trust, or will ever personally liable for the debts of the descendant?
No. So let me speak to my plans. In my plans, we make sure with the trust that we do everything to protect your trustees from situations such as that. Someone trying to sue them and hold them liable for any debts that you may leave behind. But no, the debts are yours. They're yours. They're not the people that's carrying out your wishes and your instructions. Now, they do have a responsibility that if you leave assets behind to take care of your debts, but the debts aren't theirs. Hopefully that answered the question.
Yes, excellent.
That is definitely a scenario that we try to address in advance because we know it happens.
Another question, does putting the house in the trust trigger any due on sale clauses in the mortgage on the house?
So there's this, oh my goodness, there's this act. The name escapes me, but there are conditions for your personal residence that excludes the financial institutions from being able to enforce those clauses. Is it the Sherman Act? I have to get that name, but I think it's the Sherman Act. And there are certain conditions that provided they're met, which is usually the case for most of us when it comes to our primary residence, that due on sale or advancement of you having to pay off your mortgage is not applicable, and the financial institutions cannot enforce it. But if you have something like a rental property, then that could be a different situation. And often
Mhm.
often what we do is, we could just, if there's a question for like a rental property or something, you don't like to poke a sleeping bear, but sometimes, taking the avenue of caution, we'll just contact the mortgage company and see if they're gonna have a problem with it. And if they don't, then there it is.
Okay. I think this is the last question. Will a trust have its own tax bracket for accounts that have earnings? What will the tax bracket be on that?
So when you have a trust, and the trust I'm referring to are revocable trusts, they're essentially like they're almost like a checking account or savings account. Because it's revocable, you have full control over it, right? You get to add to it, take from it. So if it's you by yourself, that trust is gonna be under your social security number. If you're married, it can be under yours or your spouse's social security number. And when you file taxes, you're gonna be filing taxes the same way you always have. Except it's gonna be in the name of the trust. So it's going to be the same. It's going to be the same.
I believe that's all the questions we have in the chat. I'm going to turn the floor over to Brother Cooley unless there's other questions to be asked. If not, Brother Cooley.
Thank you, brothers. Thank you for all your questions and all your participation in attending tonight. Please hang around, don't leave just yet. We have a special announcement that we wanted to make, but I wanted to thank Brother Hines and Brother Wilson for their hard work, their efforts in putting this together for you brothers. They really did a good job. I wanted to thank them, and I want you brothers to join in thanking them as well. Brother John Bias, if you would please stop the recording at this time.